Health Committee comes back to order. Thank you, members. I know we're all excited. So with this here, the final bill we will consider is House File 2070. Representative Dippel, can you go to the main area? Dippel, I'm sorry. Okay, Representative Dippel, would you love, whatever you want to say it, to move House File 2070 to get it before the committee?
Yes, I move HF 2070.
Okay, Representative Dippel moves that House File 2070 be recommended to be placed on the general register. We have a bill before us. Tell us about your bill, Representative.
Chair Backer, do I need to move the A1 amendment as well?
We would first give a brief overview of the bill, and then we will take up the A1.
You got it. This bill is a bill that addresses a disparity within health records. So what happens is someone who provides medical care or a hospital, a physician, anybody in the health field has to keep records in Minnesota indefinitely. So forever until that person passes away. What that does is it builds up a very large load of medical records, and we have HIPAA laws and we have other laws that protect those patients' identity and information correctly and appropriately. However, they are vast and numerous. As you can see in this very small piece of paper, there's 45 steps that these healthcare providers need to go through to be able to get those records out to the individuals who have requested them. And the individuals who generally request these records are attorneys for insurance companies. And what that does is it puts an onerous burden on our healthcare providers. Truly, it does. If you have to go through these 45 steps, especially multiple times a day, you're spending potentially hours away from patients, away from giving individuals care, and you're taking productive time away from our healthcare workers. So this bill actually helps with the cost of healthcare in our industry also, because it would appropriately monetize for those healthcare providers the time that they have to put into getting these records out when they are requested. So apart from that, this really sets a standard. Actually every healthcare provider in the state has this mandate of this is what you can charge for these records. Right now it's $20. $20 is very, very low to go through 45 steps every time and to ensure that you have patient privacy. So personally, as a business owner, I see 50 to 80 different patient records a day come through my business personally, and those are prescribed from doctors. So I don't have to extract any data or request them, but those individuals that are sending to me have to do that, and they have to store that data securely. So that is the bill. I tried to keep it concise, but it was longer than 2 minutes. Sorry.
Okay, thank you. We have an amendment labeled A1. Representative Dippel, would you like to move that amendment?
Yes, I move the A1 amendment.
And so Representative Dippel moves the amendment labeled as A1. Does, I assume everyone would have a copy of that. Can you please share us the amendment, details of this amendment?
Yes, there's 2 parts to this amendment. The first part deals with refunding fee that was paid for these records when the records weren't available. They didn't exist. And so attorneys will request records, and sometimes it's found that those records don't exist. Therefore, if there was a prepayment for those records, that should be refunded back to the requester, and this sets up that modality. Mm-hmm. And then apart from that, the second part is actually relatively simple. It cleans up some language around year 2026 and changes it to 27. and also adjusts the maximum charge annually and guarantees that happens based on a price index.
Okay. Any further discussions? Chair Levin, go ahead.
Thank you. Thank you, Mr. Chair. And Representative, is it Dippel?
It is Dippel.
Okay,
Yes.
thank you very much.
For the record.
All right, good to know that. So I'm just curious about, who you've had conversations with about this, because, obviously there's no magic answer here. Sorry, I can't see you, this room. But, this was changed a couple of years ago, and I do think that it was too low. But I'm a little bit concerned that what you're asking for in the bill is too high, and I'm just kind of interested in whether you've talked to the lawyer groups or is it the hospital association that's bringing these numbers? Where did the numbers come from?
From my personal experience, actually, dealing with individuals who have to do this on a daily basis, they've complained to me for a long time. And I've been in this industry for 26 years now or so, and I've owned my business for 17 years. So I interact with them on a daily basis. We transact with health records on a daily basis. And what they've said, I would say, consistently for about the last 13 years, they've said that the regulations and mandates that have been placed on them to provide these records has become more and more and more and more onerous. And there may have been a time when $20 was appropriate because it was really easy. They could just send the information. There was really limited liability also at that time. But as these things stacked up, it just took so much administrative time. And truly the sad part about it is that about 50% of these healthcare providers, they have to do it themselves. Now, 50% of hospitals, for instance, and so on, they might have a contractor that they work with, and that's actually very, very common for that 50%. They're big enough, and they can outsource it. But the other 50%, those are the mom and pops or the smaller organizations. They're the ones that are really, really getting hurt, especially rural areas, some suburban areas. There are definitely urban areas that are directly affected too, but it's my experience. It's my personal experience, which I don't think is anecdotal because I've worked with about 1,000 different doctors over my career in different fields. So that's where we got to the 250 is the stacking, the 45 steps. We've talked about process before in this committee, and individuals understand in this committee that process takes time, and to do it right, and especially when you're dealing with patient data, it's really sensitive and it takes a lot more time. And then you need the infrastructure in place. You need to share over HIPAA compliant servers, and you need all these different things, and all those things take subscriptions that are annual, and this money just keeps adding up. So that's kind of where that comes from.
Yeah, Mr. Chair.
Okay. Yes, go ahead.
Thank you, Mr. Chair. And yeah, thanks for that. So I don't know what business you're in, so just put that out there. But I'm kind of getting the picture, though, a little bit. Thank you for that answer. In the past, they had to make paper copies. And so having a per-page charge made sense in a way that it really doesn't anymore for electronic. And also from what you're describing, probably the healthcare provider, a bigger one might be able to do it at a lower per production cost than a smaller one. And yet what we have in the bill and what we have in the law currently is kind of a one-size-fits-all. So I don't know if I'm comfortable with the bill today. I appreciate your taking this on because I do think it's something that needs to be worked on and fixed, but I'm a little bit concerned that, with respect to the fact that you have talked to a lot of people in your life, I think that's a little bit different than having like people formally weighing in on it. And I'm just a little bit concerned that we're going from one extreme to the other here. I'd really like to see something with a little more particular rationale to it, and maybe even, maybe it shouldn't be a one-size-fits-all number, I don't know, but thanks for your work on it.
Yes. Chair Liebling, or Chair Backer, do you mind if I respond to that?
Go ahead, Representative
Great.
Pell.
So on the anecdotal side, the life experience side of things, I go to continuing education on an annual basis and have to keep up with that. And HIPAA and, of course, OSHA and all those different things are part of that continuing education. And this gets talked about in those sessions. So it is certainly practice-wide and objective information that is known within the industry. And you're correct about if we were just paying for the paper, I would totally agree with you. That'd be kind of silly and ridiculous to do a per page thing. But the issue is that you have to make sure that it's the right information. Yeah. If you transfer the wrong information or you don't get it complete or in the way that people expect you to receive that information, then you really run into problems and you shared it in the wrong way, and then you can get yourself in trouble, as you probably know too. So the per page is really parsing through the information to make sure it's correct. That would be that side of the issue. Not the paper, just wanted to make that clear.
Okay. Representative Bonner.
Can you help me?
I'm sorry, I had Representative Purcell before you. I did not see that,
That's
so.
fine.
Go
Thank
ahead
you,
with
Mr. Chair. I'll
Representative.
wait till we're on the underlying bill. Thank you.
Okay, very good. So Representative Bonner, go ahead, please.
We're on the underlying bill.
We're on the amendment right now, We're on the A1 amendment.
Okay, well, my question is to the, I guess it could apply to both. But can you help me understand, like, who is it that's requesting these copies and why?
Representative Dippel.
Yes, thank you, Chair Backer. Oftentimes, these copies are requested, as I had mentioned, by insurance companies through attorneys to try to understand the background of potential litigation or the background of a life insurance policy or the background of somebody like that. That is definitely an issue that occurs and can happen in a different industry. I work in the dental industry, and so in those industries, you have, as you understand, multiple disciplinary portions, periodontists, oral surgeons, orthodontists, general dentists. All these individuals have to communicate with each other on patient information, and if that information isn't transferred appropriately, then again, people get into big trouble. And so some of that stuff can move freely. But if there's issues, if a patient feels like there's malpractice or something along those lines, then it starts to roll into a larger process in which we're talking about. It's a bigger undertaking to try to legally meet the bar of this requested information.
Okay. Follow-up? Go ahead, Representative Bonner.
So you're using this primarily for things like insurance or legal proceedings, or those are the folks who are typically engaging these specific types of copies?
Most commonly, yes.
Okay.
Okay, that is helpful, thank you.
Okay. And Representative Purcell, you're on the main bill, correct? Not the amendment?
Yes.
Yeah, thank you. Okay, so any further discussion about the A1 amendment? Okay, hearing none. Those in favor signify by saying aye. 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 Those opposed, say nay. Okay. A1, the amendment passed, the motion passed for the amendment and prevails. So now Representative Dippel has an oral amendment for House File 2070. Could you please share us about that amendment?
Yes, I move the oral amendment for 2070 to strike the changes on line 2.21 to 2.24, and this removes changes to paragraph F to address concerns from the Minnesota Association of Justice.
And if you could, Representative Dippel, could you speak on those just a little bit more precisely?
I'd be happy to call up Mr. Holliday to speak to those issues.
Mr., state your name and just talk about that striking on that oral memo. I think that's important because we don't have that in our packet right now.
Yes, thank you, Mr. Chair. My name is Cody Holliday of Frederickson Government Relations. I represent the Alliance of Health Information Operations and Standards, who is the main primary proponent of the bill. My communications with the Minnesota Association of Justice on this oral amendment was a discrepancy in our interpretation of this paragraph and the changes that we were hoping to make. The current statute with the changes that were brought forward by the Minnesota Association of Justice in /24 were to have a retrieval fee of $10. Our intent was to get the language consistent with the rest of the statute, where we're talking about records versus retrieval fees. So that was our intent, and to have that be no more than $10. The feedback that I've received from the Minnesota Association of Justice, I don't want to put words in their mouth, though, is that their interpretation would be that if we made these changes, the records would be charged at no more than $10, but a retrieval fee could be whatever you would want it to be, and that was not our intent. So instead of making the change, we'll just go with current statute on that.
Okay, thank you. Thank you for that clarification. Is there further discussion on the oral amendment which strikes the changes in lines 2.21 to 2.24? Chair Liebing.
Yeah, thank you, Mr. Chair. I'm still confused about what this is doing. So it seems to me that okay, so the way the bill is written right now, it would allow a per-page fee or X-ray fee to be charged to a patient in this situation of doing this appeal. And we're striking that, right? So that it will go back to being more favorable to a patient who is appealing a denial. Is that right?
Mr. Holliday, right?
That is correct.
Okay,
Okay, thank you.
okay. No further follow-up on that?
No, I think-
Okay, thank you.
I got it.
Okay, any further discussion?
God, I hope not.
Hearing none, those in favor signify by saying aye.
Aye.
Aye. Those opposed? Okay, the motion does prevail. The amendment is adopted. Today, we also have a few testifiers. Is Sue still here? Is Sue what, virtual? Sue,
She's at the St. Paul Grill.
Zoom, can you hear us?
Yeah, that's what she's on.
She's popping up.
6:30.
We also have a few testifiers. Is Sue still here?
Yes, I am here.
Is Sue what, virtual? Okay, we have a little delay.
She's at the St.
Okay, Sue, can you hear us?
You need to unmute, please.
Yo, you were on mute?
The meeting is muted.
No.
It is not muted.
We hear
Is Sue still here?
Yes, I am here.
Is Sue what, virtual? Okay, we have a little delay.
The meeting is muted.
Okay, Sue, can you hear us?
You need to unmute, please. You were unmuted. The meeting is muted.
It is not muted. Is Sue still here?
Yes, I am here.
Audio does say it's muted.
I cannot hear any feedback from the meeting on my computer, but I can certainly relay messages.
There seems to be, if you go to the, there's a line there, seems to be that it is not on.
Is it supposed to be?
On the bottom.
Does she realize there's 30? Is it signed up there?
Now she's on it.
Gee, fucking whiz.
Should I go fix it or just leave it?
That's correct.
Okay, while we're working on that, we're going to do an in-person one.
Oh, we never
What's
came
that?
out here.
Liz is virtual too? Oh, okay, so we're going to go to Joel Carlson. did you want to address the committee?
Oh, yes, he does.
And then Chuck?
They both want to come up.
Chuck Shane. What's that?
Slain with an L.
Oh, okay.
SL.
He
SL.
has a speech impediment.
It's spelled differently. Okay, cool. I see. So Slain. Okay, please state your name, and we would ask to keep this to 2 minutes. Is Slain, Mr. Slain, or Mr. Carlson going to go first?
Mr. Chairman and members, I'm Joel Carlson. I own a legal research and government affairs business. I'm here on behalf of the Minnesota Association for Justice. And with your permission, I'll have Mr. Slane go first, and I have just a couple comments on the end. You're going to hear a pretty different story about the cost of medical records and the medical record companies that we deal with. This is a access to justice issue that we brought to the legislature to have corrected. And when you hear the costs of what some of these records are for a patient to get their own records, I think you'll know why we brought this bill forward.
Go ahead and do your best to keep this to 2 minutes.
Thank you. And thank you for coming here so late to listen to us talk here tonight. We appreciate it. My name is Chuck Slane, and I am a partner at TSR Injury Law. So my staff and my teams are requesting medical records every single day, hundreds of times. So I'm thoroughly familiar with the business of getting medical records from medical facilities. One thing that you heard from the proponent of our bill is that the people who are paying these bills for the records are attorneys for insurance companies. That's true. But it's also my clients, real people who have been injured, who are seeking justice. And the cost that we are charged for all these medical records gets deducted from their settlement. So the more money that someone charges for records, the less justice people get. That's why we're here. When we decided, was it 2 sessions ago now that we changed this law? The reason why we did is because these bills were just getting out of control and my clients couldn't afford to bring cases. I'll give you an example. I brought with me a medical, a bill for copying one of my clients' medical records. And it's from this company called MRO. And you'll see that they provided written testimony for you in this case. They wanted $18,580 to get my client's records from one facility. He'd seen 10 facilities. I was talking about this issue with Judy Seeberger, and she and I are both licensed in Wisconsin, and she said, you know, in Wisconsin, it's free. I couldn't believe her, because I had a client who had just spent 3 months in a hospital in Wisconsin, so I ran back to the office and requested the records electronically. Sure enough, I got them for free the next day. It took less than 24 hours to get the same amount of medical records for zero. Now, in Wisconsin, the law does not allow the medical provider to charge a fee for looking to see if there are records or verifying that the authorization has been filled out correctly. We didn't think that would be fair. So what we did is we included that they can always charge up to $20 to get paid for what it is that they're actually doing. Because keep in mind, there are no paper records that are trading hands. And if someone still has paper records that they need to deal with in their office because they haven't converted, you know what they do? They put them in a scanner and they send us the images electronically. This is the world that we live in. Now, one thing that I noted is there was testimony, I believe, in written form talking about 47 steps, was it? 45, 47?
45.
45 steps.
And if you can wrap that up here in 30 seconds.
I will wrap that up with this.
Thank you.
I went to MRO, remember that's this company. I went to their website. They're boasting about the fact that they're using AI robots to automate the tasks so that humans don't have to do anything in this process. And why do they do that? Well, they tell us right on their website. We want your employees to actually engage in higher value tasks rather than the menial task of responding to medical records. So folks, we fixed this problem already, and there's no reason to go backwards.
Okay, thank you.
Mr. Chairman, just
Mr.
on
Carlson,
a
do you
couple
want to?
points just directly on the bill.
Please.
Mr. Chairman and members, if I could point to lines 1.6 and 1.7. This changes the law so that a patient now has to prove that for their free request for records for their undefined own purpose, which means if you're in a car accident, your records are for the insurance company, even though you should be able to get them for free. By letting the medical records company define whether or not it's for a patient's own purpose is inconsistent with the law, and we do not accept that as a minor technical cleanup change. As to the costs themselves, we reject any per-page charge any longer, and here's why. The reason you get to an $18,000 bill is the way they generate your per page right now is per data point. If you get your temperature taken in the hospital every hour, you get a page for that one data point for your temperature for that day, and it goes on and on and on. Every single data point is a new page.
Well, that sounds like a scam.
Anything that we do that has a per-page charge, which we got rid of ever since 2015 with the Electronic Medical Records Act that you approved, everything is electronic now. And that was just a profit-generating center, not for the hospitals, but for the medical record companies that are here promoting this change to now go 12 times higher than what we are right now. This is just unfair. It denies people their right to even find out what happened by getting an $18,000 bill just to look at the records, and we're strongly opposed to this bill. Thank you, Mr. Chair.
Thank you. Okay, now we're going, I believe, we are ready to rock and roll on Zoom. So we have Sue Nath, Director of Minnesota Health Information. Can you hear us now?
I can. Thank you, Chairs Backer, Bierman, and members of the committee. Good evening. It is Sue Nathy. My name is Sue Nathy. I'm the Executive Director for the State of Minnesota Health Information Management Association. MINHEMA represents over 2,500 health information professionals across the state who support urban and rural healthcare organizations with managing protected health information. I'm also an experienced health information management professional with over 25 years experience working in a variety of healthcare settings in rural Minnesota. I'd like to share MINHEMA's support for House File 2070 and our concerns with the fee structure currently in place. The existing fees and fee caps on what providers can charge third-party requesters do not reflect the current cost of processing health information requests and protecting patient data. These fees are usually paid for by plaintiff lawyers and legal counsel for insurance companies for personal medical records. Please let me be clear. The fees and the charges that are proposed under House File 2070 only impact charges to third-party requesters and do not apply to the patient or the patient's provider who is requesting records for treatment purposes. There is no fee in these situations. There are those who believe the retrieval process for medical records is a simple push of a button, and hopefully that'll be the case someday, but it is not our current reality today. A single health system has multiple health records, including EMRs, paper, microfiche, microfilm, CDs, USB drives, a variety of systems on which protective health information is stored and still maintained today. Many healthcare organizations have large volumes of health information not interfaced on the EMR and may be stored offsite in rented facilities where they have to maintain that information. The effort to retrieve and reproduce the appropriate requested information and engage with requesters who may and often do change the parameters of a search after initial communication is not reflected in this current fee structure. It does not recognize the effort to protect the health information of the patient, to comply with the HIPAA and Minnesota Health Records Acts. Again, thank you for this opportunity to share your support for House File 2070, and I would be happy to answer any questions you may have when it comes to releasing data in the state of Minnesota.
Thank you. And then we have one more on Zoom. We have Liz McLilly, I don't know.
McElhenney.
Thank you. Liz, you are on deck.
Okay. Thank you, Chair Backer, Chair Behrman, and committee members. My name is Liz McElhenney, and I'm a health information professional with nearly 20 years of experience. And I'm here today in support of House File 2070. While I have submitted written testimony to the committee, I would like to speak to you today about the criticality of having trained health information professionals involved in the release of information process. In doing so, I'd like to share a story from earlier in my career that demonstrates the importance of the right information being released to the right person in the right format at the right time. The encounter happened over 10 years ago, but I still remember it very clearly today. I was assisting a patient who came in with her children to request her medical records. That part was completely normal. At a certain point in the conversation, the mother motioned me over to the side and quietly asked if I could make sure that any bill would be sent directly to her attorney and not to her house. The visits she was requesting were abuse evaluations. She knew that if her husband saw an invoice for medical record copies, that he would know that she had taken the children in to be seen, and that he would know that she was planning to leave him. I did not bill the patient. Patients do not get charged for their medical records. A patient's medical records contain some of the most private information about that person, including information that they may not have told a parent, a spouse, or friends. Having a trained professional to identify highly protected information, such as treatment for domestic violence and sexual assault, means that this information has the stronger privacy protections that it justifiably needs. There's a common misconception that electronic health records separate out the sensitive health information or flag it for attention, and this is not the case. It still requires individuals trained in all software systems utilized by that provider or hospital system, as well as the individual quirks of those applications. I want to thank you for the opportunity to speak tonight.
Okay, thank you. Is there anybody in the audience that wants to testify? I don't think so. Okay, we'll take questions, members. Representative Hewitt.
Oh, I thought there were other people in line before me.
Well, yeah, you know what? I'm so sorry. Representative Purcell, you are on deck because you were held from before, so thank you.
Thank you, Mr. Chair. I am wondering about, is it, the current fee is on line 2.10, is it $1,500 for any request to the bill author? And then my follow-up is, then how does that change with the adjusting for inflation? That's the starting point? How did you get to that dollar amount? Thank you, Mr. Chair.
I'm going to have Mr. Holliday come up and answer those questions. And to my best knowledge, it's up to $250 initially, and then it expands out depending on requests. But I'm going to let Mr. Holliday give you the definitives on that.
Go ahead, Mr. Hawley.
Thank you, Mr.
Holiday.
Yes.
Thank you.
Thank you, Mr. Chair. Representative Purcell. I'm sorry, I was talking to House Research. Could you repeat the question?
Yes, Mr. Chair. How did you land on 1,500, and how does that adjust for inflation?
Thank you, Mr. Chair. Representative Purcell. Yes, so that dollar amount actually was, we originally were going to keep it at 500, which is current statute. That number came from a medical provider over in the Senate who deals with, he does not outsource the retrieval of these records and felt that 500 was too low. In fact, his spouse processes these requests. So he felt that that number more adequately reflected the cost of processing these requests. And then that number will be adjusted with inflation going forward.
Follow up there, Representative Purcell? Okay, here's, if there's no objections, we were given an extra 30 minutes and so forth. I've talked to the, communicated with the author, and with what we've talked about, there does need to be more work to this bill. So if there's no objections from members, I'm going then ask that we lay this over so they can do some additional work on this. Is there any objections to taking that path? Okay. We are in agreement. So with that there, and I thank you for everybody for being here tonight. So with that, we will be laying House File 2070 on the, what's this? As amended, we will be laying that over. Okay, members, so thank you so much for coming in this evening. Thank you for House staff. And everybody be safe, drive home safely, and we will be here on Monday with Chair Berman with the gavel. Thank you, members. And we are adjourned.